Okay, imagine this. You finally found your dream home. You did everything by the book. You even got a professional survey done. But just weeks after moving in, disaster strikes. Now, this isn't some made-up story. It's a real case that completely changed the game for home buyers. And really, it all boils down to one big question.
Yeah, this one really gets to the heart of it, doesn't it? It's all about trust and responsibility. I mean, you pay an expert for their opinion. You bet the farm on it for the biggest purchase of your life. And then it all falls apart. So who's on the hook? Who has to pick up the pieces? Well, that's exactly what we're going to dive into. All right, here's our game plan. First up, we'll get into the story of that dream home nightmare. Then we'll look at the legal question at the center of it all. No contract, no case? After that, we'll cover the landmark decision itself, and finally, we'll talk about why this whole thing still matters so much today.
Okay, so let's start at the beginning with the story. Because this isn't just about dry legal stuff, right? This is about a real person, a first-time homebuyer named Miss Smith, whose personal nightmare ended up making legal history.
So everything started out just like any other home purchase. Miss Smith applies for a mortgage, the bank does its thing and hires a surveyor, a firm named Eric S. Bush, to check out the property. The report comes back, says everything's fine, no red flags. So Miss Smith, trusting that expert opinion, goes ahead and buys the house. And then the chimney collapses. Just like that. So what on earth happened? Well, it turns out the surveyor had missed something huge. The chimney flues. They weren't supported at all. We're not talking about a little crack here. This was a massive, dangerous structural flaw. And as you can imagine, this is where the real fight begins.
All right, that brings us to the legal battle. Miss Smith obviously sued the surveyor, but the surveyor's defense was, a pretty standard one, and it was built on a really simple but powerful idea.
And here's the standoff, the two sides of the argument. The surveyor's team basically said, hey, our contract was with the bank, not with Miss Smith. Plus, we put a disclaimer right there in the report saying we're not liable to the buyer. But Miss Smith's argument was just pure common sense. You knew I was going to read that report and trust it to buy the house.
And this is the core question, isn't it? Can a professional just use some fine print to wash their hands of all responsibility, especially when they know someone is about to make a life-changing decision based on their work? The courts had to figure this out, and it all hinged on this one really important legal idea.
And that idea is called duty of care. What is that? Well, put simply, it's the legal obligation to be reasonably careful so you don't cause harm to others who you could expect to be affected by your actions. So the million-dollar question was, did the surveyor owe this duty of care to Miss Smith, even though they never signed a piece of paper together?
This was such a huge question. It went all the way to the top, to the House of Lords, which was the UK's highest court back then. And their decision was about to make some serious waves.
And you can get a real sense of their thinking from this quote by Lord Griffiths. He says the relationship was sufficiently proximate. Proximate just means close. So what he's saying is, even without a contract, the surveyor and the homebuyer were so closely linked in this whole process that it created a real responsibility, a duty of care.
And the verdict was in. The surveyor was liable. The court sided with Miss Smith. It was a landmark decision. That disclaimer in the fine print, the court said it wasn't good enough. This was a massive win for consumers everywhere.
So how did the court actually reach that conclusion? Well, they used a pretty straightforward three-part test. First, was there proximity? Yes, absolutely. The surveyor and the buyer were closely connected. Second, was the harm foreseeable? You bet. It was totally obvious the buyer would rely on the report. And third, was it reasonable to impose this duty? The court said yes, it was fair, just, and reasonable to hold the surveyor responsible.
Okay, so this all happened a while ago. Why are we talking about it now? Why does it matter to you today? Well, it turns out it matters a lot, especially when we're talking about trusting professional advice. So here's the bottom line, what this case means for all of us. First, it means professionals are responsible for what they say and the impact it has. Second, those little disclaimers, they aren't bulletproof, you can challenge them. Third, and this is huge, the law has your back when you reasonably rely on an expert's advice. It really set a powerful precedent for accountability. Honestly, because of Miss Smith's fight, anyone buying a home today has so much more protection against this kind of thing. Think about that. Her personal nightmare created a legal safety net that protects all of us. It was a victory for her, but really, it was a victory for everyone.
And that kind of leaves us with one final thought, doesn't it? In a world that's just packed with complicated terms and conditions and expert advice, it really makes you wonder,
Who else owes you a duty of care?